Tonight we have something really good, a hot topic in the news this week. He's been charged with crime. This is a show where I try to educate real stories. Welcome to Truth and Justice with Vivian King. I am your host, Vivian King. We have another exciting show for you tonight, and we welcome your call-ins. The number will be flashing throughout the program, so please call in. I have some very good friends of mine that are here. I have Mr. Bill Habern, who is a lawyer that practices primarily parole law, and his partner, David O'Neil. They are both in the studio tonight, and they have brought in some very special guests who've had a very interesting experience, horrible experience with the criminal justice system, but one that I believe we can use to enlighten people about the system, empower people about the system, and educate people about the system. So hopefully you'll register to vote, you'll participate in jury duty, so that people who are wrongfully accused of crimes are not afraid to fight a system that is stacked against them. Because remember, when people go in the courtroom, everybody in there works for the government, except the defendant and his lawyer, usually, that go in there. So we have in the studio Mr. Michael Trevino, and we have his wife, Sandra Trevino. We're going to take about 5 minutes to let everybody tell their story, so you'll find out how interesting it is, and then I'll let his lawyers who are here today talk to you from a legal standpoint about what happened to him. So let's start off, Michael, just jump right into it and talk to me about what happened to you. Give us a little background about your marriage, your child, and the case was about sexual assault of his own biological daughter, and what happened with him over the last 20 to 25 years, 24 years to be exact. So tell us about what happened.
Well, I was wrongfully accused for something that I didn't do, which was molesting my daughter. And I spent a lot of time that I shouldn't have spent on cases and stuff, and I'm sorry, I'm not. I
know, it's okay, it's okay. So let's talk about this. So in so you were with your child's mother.
Yes.
What years? Do you remember what years you were with her?
I can't remember. If we got married like in 1981 or 82, I think we got married. We got divorced in 85 or 86, I think.
Okay.
And then 87 when we got divorced, or 86 when we got divorced, things just started going downhill with her. And she married another man and became very spiteful with me because of the other man that she had married was jealous of me for what reason, I don't know.
So in 87, 86 when you got divorced,
86.
you had 2 children with your first wife. You had a son and a daughter, is that correct? And then in 87, now you're divorced, you marry Sandra.
Yes, ma'am.
Or you get with Sandra.
Yes, ma'am.
And then your ex-wife marries. So now there's a stepfather raising your 2 children.
Yes, ma'am.
2 small children.
Yes, ma'am.
And in 87, you move away. You were living in Austin, Texas at the time.
Yes, ma'am.
When you were married to your first wife, and you met your now current wife, Sandra, who's in the studio. And then you moved to South Carolina in 87.
North Carolina.
North Carolina, I'm sorry. Okay, so you moved to North Carolina with Sandra. And so now, if you're going to see your children, it has to be on holidays or the rare occasions that you could come back to Austin.
I would make several phone calls to my ex-wife and tell her, listen, I'd like to fly my kids to North Carolina so they could have a vacation with us, because my stepson would fly from Corpus to Charlotte, North Carolina, where we were living at, and they'd go on vacations. And I asked her several times if we could do that. And she said, well, I don't know. I need to talk to my husband and find out if that's going to be okay, and this, that, and the other. So afterwards, she called me back and said, no, that he didn't think it was fair to our kids, because their kids weren't going to be able to go on vacation. It's like, wait a minute. These are our kids. You know, it has nothing to do with him. And she said, well, he's got the final say, and I didn't like it. I fussed and argued with her and never could get her to budge, so I never could spend time with my kids, take them on vacations or anything like that, like I would my stepson.
Now, how many children did your ex-wife have with her new husband?
2.
2, okay. All right, so tell us what happened when you found out that your 5-year-old daughter had accused you of raping her.
It was devastating.
And how did that happen? Since you were in North Carolina, did they call?
No, I came to Austin, Texas to visit my family, my new family. My father-in-law was having a birthday, so we came in September for his birthday, and that's when I learned that I made a phone call, and that's when I learned that she had put these charges on me. And then I got a lawyer and started from there and passed the polygraph test and whatnot. And then I went back to North Carolina, came back and forth every 6 to 8 weeks to go to the courtroom just to have it, you know, postponed for another 6 to 8 weeks. We did that for 4 years till finally I had to move back.
For 4 years?
Yes.
And so tell us about, you said you hired a lawyer and gave a lawyer $10,000 to represent you, and that's a lot of money in the 80s.
Yes, at that time it was a lot of money, I was told, in 1990.
Right, in 1990. Okay, so you hire a lawyer, and what was your expectation when you hired a lawyer?
Well, he was saying that it was an easy case, it was an easy and shut case, since I did not live in Austin at the time that this happened. I was living in North Carolina at the time. He told me it was an easy case to be open and shut, and turned out to be it wasn't as easy as he said it was.
Well, what did you expect when he said it was easy? Did he say he was going to get it dismissed, or was that just your interpretation of what?
That was my interpretation, that it was an easy case, that I had nothing to worry about, that for me to pay this money and he'd see that I would, you know, didn't have to go through all of this.
So you go back and forth between Charlotte, North Carolina, flying back to Austin to go to your court dates for 4 years.
I drove, never flied.
Oh, wow. How long was that drive?
That drive was anywhere between 17 to 20 hours.
Wow. Wow. So for 4 years, you drove back and forth. Now, what happened to, did you do it?
No, I didn't do it. To my daughter, no. I drove back and forth, but no,
I'm just saying, did you do the crime you were accused of?
No, ma'am, no.
And so...
But somebody did.
But
yes,
somebody did. And
somebody did.
But you ended up pleading guilty to a crime you didn't commit and got probation for 8 years. Is that correct?
Yes, ma'am.
What year did you plead guilty to the probation?
94.
So 94, you were on probation for 8 years, so that's until 2002.
Yes, ma'am.
Is that correct? Now, why would you plead guilty to a crime for raping your daughter if you didn't rape her?
You didn't plead guilty, Michael?
I didn't plead guilty. I pleaded not guilty.
No, you
the
had
whole
to plead,
time.
No, you have to plead guilty or no contest to get a plea.
I pled guilty the whole time.
Not
the
guilty,
judge,
Michael.
I mean, not guilty the whole time. The judge, the visiting judge that was there, scratched off everywhere on that long piece of paper and wrote in not guilty everywhere. So I had my wife and my sisters look at that paper because I can't read and write very well. So that's when I asked the judge that if my wife could see the paper, and he said yes. She saw it. The paper was all scratched up. I signed that piece of paper. That piece of paper is not in my file now. That paper's there, but it don't have my signature on it.
Let me ask you this, but still, tell me what but you did accept the probation.
Yes.
So you thought you pled not guilty to a case and you got probation.
Yes.
What did they make? And so then you had to move your family back from North Carolina to Austin to be on probation for 8 years.
Yes, ma'am.
You got deferred adjudication.
Deferred adjudication, yes.
Yeah, so that's the discussion of deferred sometimes, that, as you well know, when lawyers get into that with their clients, it can be twisted and to some degree misrepresented. That's what he walked out of the room with, was that this is going to be dismissed. Is that not correct?
Yes, sir.
I got you. So you thought you got deferred adjudication, a type of probation that would end up being dismissed.
Yes, ma'am.
And from 94 to 2002, there was no such thing as sex registration at that time, so you didn't have to register, did you?
Well, I registered whenever it started, and I forgot what year that they started mandating to register. I started registering that when it first started to register up till just this year.
So in 94, when you took the probation, registration wasn't a part of it. So you thought it would be 8 years, get off of it, case dismissed, get back with my life, clean record.
Yes, ma'am.
That was your understanding.
That's what I was told.
And but then in 96, your conditions changed and they tell you you have to start registering. How did that make you feel?
Awful. It felt like I was betrayed by my lawyer, the justice system, and then just, I mean, that I was failed.
Okay. And so at some point, though, your daughter makes this allegation when she's 5 years old, but then at some point she recants her statement, which means that she says that I said it happened, but it really didn't happen. Let's let your wife talk about that. Sandra, I want you to have a little time on that. So tell me how it happened that your stepdaughter came and said that it didn't happen.
She actually notified her biological brother and told him that she was ready to tell the truth, that she was tired of living with a lie. So this brother, my husband's younger son, Michael, called him and said, "Dad, Christy's ready to tell the truth." At that point in time, my husband knew that he couldn't be anywhere, would prefer to stay away from her because he didn't want any trouble. I contacted her and I asked her what was going on. She said that she was ready to tell the truth, that she was tired of living the lies that she had lived all these years, that she didn't want to live the life of her mother, that she wanted to have a better life. So I said, fine, if you're ready to tell the truth, I will pick you up tomorrow and we will go to the district attorney's office. I picked her up, drove her to the district attorney's office. I demanded that Rosemary Lindbergh meet with us.
And tell the viewers who Rosemary Lindbergh is.
Rosemary Lindbergh is the district attorney of the Travis County in Austin, Texas. She actually had Victim Services Director meet with us. They took a recorded statement with Christy in the room. I was there present. She then recanted her story and gave full details of what happened, how it happened, and indicated that it was actually the stepfather that had done this to her.
And why did she say that she would tell such a lie on her biological father when, in fact, her stepfather was the one raping her?
She told us that her mother is the one that told her it was her dad that did it.
Well, she was also under physical threat and being abused.
She was physically being abused, as was the mother and my husband's younger son by this gentleman.
People always wonder how, gentlemen, people always wonder how this happened. So talk a little bit more about what she said, how it went on with the stepfather.
She indicated that the stepfather would get her in the evening and give her Tylenol PM, drug her up, so that he could do whatever he wanted to do with her. They lived in a home that is not any bigger, I want to say a one-bedroom home with 4 people living in it. She told us that she could hear her mom and her stepfather having sex. And she wondered why her mom could never hear her crying out to have this man get off of her. And that is why we feel that we need to make a change, because it's not always the biological father. These cases need to be investigated. It shouldn't be when somebody comes and makes an accusation that you just take that person and say, you did this, you're labeled. There must be an investigation done.
And you also said that there were 3 occasions that his daughter actually recanted.
Yes, she recanted at 18. We had many doors slammed at our face. When she was 18, I took her to the Department of Human Services. At that point, it was Dana Blaisley who was the prosecutor for Michael's case that she had prosecuted. It was her decision whether she wanted to open the case. She did not want to open the case. She said that Christy was not credible, so she refused to take it any further. Christy then recanted at age 24. We took her to see an attorney by the name of Carolyn De Niro, who was willing to start the habeas writ of corpus. Christy went into her office and told the truth that her dad didn't do it, that she wasn't afraid of him. She signed a document. And at that point, the attorney wanted more money and more money, more money, and we weren't getting anywhere. So it just died. I then continued to fight and write letters to leaders and to everyone that I could, president, governors, everywhere, to for people to see what was going on. And finally, at 29, when Christy told the truth, the district attorney of Travis County requested that this case be reviewed. My husband's case was reviewed by a professor at the University of Texas, and a unanimous decision was made that my husband was not guilty of doing this. He was reviewed by a forensic physician who said that my husband had no traces of pedophile, and that these cases link from broken families that tend, at least he also indicated that young children are brainwashed, they are told what to say, and this is one of those cases.
Wow. Okay, Bill, let me let you comment on that. This is a very interesting case, and how did it come to your attention?
They called me one day after the exoneration had taken place, and were interested. They were aware of the fact that Richard Gladden and I had done a series of civil rights cases on behalf of sex offenders who had no sex offender conditions. And they were interested in pursuing some kind of litigation if they could find anybody to sue. And that's the problem. There is nobody to sue. About that time, the Supreme Court had just come down with a new opinion about you can't sue the DAs. This is kind of the hole in the actual innocence statute in Texas, because had this man gone to prison for those years, he would have gotten $80,000 a year.
Wow.
For being wrongfully detained and incarcerated. Yet he successfully completed probation, so he didn't go to prison. So he doesn't get a penny. And let me tell you why I think there is a hole here. I'm not talking about when someone who's successfully completed probation is found actually innocent paying them. But if they are convicted of a crime that the law says is a stigmatizing event, I think that's the key to it. It's got to be an event that is stigmatizing, just as the courts have said in the Coleman case that controls these cases we've been doing. And carrying around the label of a sex offender, where you must live for 8 or 10 years, as he did, under these horrible conditions of supervision that are so strict, and then being stigmatized in the community by being limited where you can live, by being hard-pressed to find jobs. I'm not saying that we give them $80,000 a year when they never went to prison. I'm just saying this is something the legislature needs to consider. And what do you do with people like Mr. Trevino, who have all along been actually innocent, who went through this 10 years or more of hell and doesn't have anybody to sue, doesn't have any remuneration for the wrong that has been imposed on him? I think it's something that needs to be considered and undertaken, and I have the good luck to be on the board of directors of the Innocence Project out of Texas Tech, and we just took this up last Saturday at a meeting, and it's something that there'll be some discussion about.
That's a very good point and a very interesting point. Dave, let's let you weigh in on this issue.
Well, I think as horrible as what happened in this case is, what's perhaps even more distressing is the fact that there are many folks sitting in the position that you were in who unfortunately don't have someone come forward with a recantation. How many times did your daughter come forward?
3 times.
3 times, and how many years did it take?
22.
22 years. How many children are not going to come forward?
Right.
And how many have come forward, and we've seen it often, and they've not been believed? The same court that sat there and passed judgment saying we believe this child of 5 or 6 who says that this occurred, this horrible thing, almost unbelievable thing occurred, when they turn 18, 20, 25 and come before the courts won't give them that same respect when they go through the trauma of saying, I lied. I put my father or my stepfather or some other loved one in prison, and I have to live with that for the rest of my life, and the court says, sorry, we don't believe you. And the trauma that inflicts on that victim again, and it's just horrible. And as unfortunate as what you went through is, there are those who are in the position where they'll never get relief. It's unfortunate that he's not compensated. That is a tragedy. But it brings to mind also that individuals such as this case, where you have an innocence claim, are the most difficult cases to get through probation or parole.
Right.
I think there's a stereotype about sex offenders. I know that Texas applies a one-size-fits-all mentality where all sex offenders are treated like Jack the Ripper. Those of us who've been through the criminal justice system from either your end or our end know that many of the sex offender cases are individuals who were 20 and 21, had sex with a 16-year-old girlfriend, and maybe they were fortunate enough to get probation. But nobody sat down and told them about sex offender treatment and the horrors that you'll suffer through during that. The conditions of probation or parole.
Hold that thought, Dave. Let's take a call. We have a call to come in because that's another interesting topic about the conditions of probation and what you have to go through, and we can have a whole roundtable discussion about that. Caller, you're on. Thank you for calling Truth and Justice with Vivian King.
Yeah, hello there, Miss Vivian King.
Hey, how are you?
I'm doing fine. You know, I call you every week.
You're my biggest fan.
Yeah, biggest fan. I want to say hello to your guests. And I do have a question. I want to know, I will be voting for you. I'm ready to vote. And you and Hazel Jones, I'm trying to get y'all in there.
All right, call me at my office.
Okay.
All right.
Okay, what I want to ask, what about the mother and the stepfather? Should they be like culpable or something?
They should be culpable. I'll let all the lawyers weigh in on it. Because the little girl, the statute of limitations for molesting a child is when they turn 28. After they turn 28, you can't charge them anymore. So it's 10 years after their 18th birthday. So at 29 is when she's 29 years old, when the DA now accepts her recantation, which is her saying it didn't happen, and who actually did it. And so now it's too late to file charges. If she had done it at 27, they could still file charges on him. But a lot of people are hesitant about, DAs are hesitant about taking cases that are that old because it happened, allegedly happened when she was 5. However, I do think there was extra evidence on her, suspected evidence that maybe would have made it probative, like there might have been a child.
And if I might add to that, in this case you have a situation where, let's say you sue the parents, if you could prove some culpability or mens rea in there, the likelihood of recovery is a waste of time. And to bring one of these cases and to put it to trial and to prepare and to have the experts and to do it right is exceptionally expensive. And if you can find me a lawyer that's going to take one of those where you go to the end of the rainbow and the pot's empty, it's just not going to be something they're going to be able to do because the task itself's overbearing, and then you wind up doing it for nothing. And you know, we don't have much of a when it comes to post-conviction issues in this state, we don't have a public defender service that's funded by the state. In those states where they do have state-funded public defender services, they always have a line item and a section of lawyers that do prison and jail work that would take this kind of thing on or would look at this kind of thing. Now, believe me, I'm awfully proud of and thank the local public defender service here that is county funded, not state funded. I think they do a wonderful job. But on a statewide basis, there's just not the legal resources out there unless you can show a lawyer the potential of a pot of gold at the end of the rainbow, or unless the client can
pay for the defense themselves. So does that answer your question, caller? And do you have another comment for the Trevino family?
I just want to tell which Mr. Trevino ought to look, and I enjoy your show.
Thank you, sweetheart, and you know I love you.
And I love you too.
Bye-bye. So anyway, let's talk about the consequences of probation. So you're on probation for a crime you didn't commit, and that was from 94 to 2002. What type of conditions and programs? First of all, you had to move back here from North Carolina, so you have to move your wife and your stepson back here after you've settled in there. You've been there for 7 years. You have to move here just to be on probation for raping a child you didn't rape and not to even be able to have contact with your children. I'm sure you couldn't have contact with your son or your daughter.
Neither one of them.
So you're back here. What did they make you do?
Well, I went to sex offender classes for a while, and they got tired of listening to me say that I didn't do it. There's things that you have to do and say, and one of them that they wanted you to admit, give your name and admit your guilt or whatever you did and stuff, and I would never admit to it. And then they'd get you to write different things, daily things. 3 times a day you had to write a story as to what you're doing today and stuff like that. And then they even come down to asking you, how do you have sex with your wife or your spouse? And it's like, wait a minute, I drew the line there. I turned around and asked the instructors or the people there, I said, wait a minute, when you tell me how you have sex with your partner, I'll tell you how I have sex with my partner. Until then, don't ask me that question. That's intimate between me and my wife. That's private. Nobody needs to know that.
Wow. So that's how nosy they were being. 'Cause there's
yes.
no, what good would that do?
I have no idea. They was just being nosy. I guess they just wanted to know how you did things, I guess.
Did you have to pay for those counseling sessions? Or
yes, I had to pay for it. And then...
and you had to go to specific places, so it would be almost like the government picks these counselors. You can't pick your own counselor. Nope. You're paying them, so to me, they don't really have a good incentive to really help you.
Right.
Did you find that to be the case?
Yes. Yes, I found that to be the case. A lot of times, if you got in trouble, they would decide what was your punishment if you didn't turn in one of your papers on time or whatever. Sometimes the punishment would be go outside and pick up cigarette butts for 15 minutes. And it's like, that's not, you know, you're not getting nothing out of that.
For a counseling class?
Yes, you're not getting, that was your punishment for not turning in a paper on time or something.
And sometimes I would imagine that would be difficult for you since you work construction. So to keep a journal 3 times a day when you're out in the field working is difficult because it's not like you're at a desk or at a computer where you can sit there and write your thoughts down. You're trying to make sure that you hit the hammer correctly and that you line everything up properly. So that's crazy.
Let me intercede a minute about these sex offender treatment providers. You know, if you're a psychologist or a psychiatrist or you're a welfare worker that's licensed to do counseling, you can evaluate a client and you can testify in court about your evaluation of the client. But then if the client goes into therapy, the ethics of those professions prohibit you from being both the evaluator and the treator. Yet there is no such ethical rule in the statute that applies to the sex offender treatment providers. So the treatment provider can evaluate the prospective client, say, yes, he needs sex therapy, and then who determines when he's through with sex therapy?
The same person. So they'll never think you're finished.
That's right.
One of our lawyers
that's going through that
has come up with the theory that maybe if we check these sex providers and we find one of them may be a psychologist or a master degree social worker with the therapy authorization, maybe we ought to file grievances not with them as sex offenders, but as the fact that they are they're over here operating under this other license too.
Right.
And the legislature needs to do something to fix that because this is all a big money scam as far as I'm concerned.
It's a big money scam.
I've always said that because I've got the man that's which I call a friend of mine, and he actually did the offense, you know, but he's gone through that program I think 4 different times, and at the very end they tell him he's got to start over because he did not complete it.
That's what I mean.
And he's got to start it over again, and he's done it over and over and over again.
Wow.
Right towards the end, you didn't do it, you start back over, square one, and he's back in it again for another 5, 6 years, however long it takes you.
Our viewers are watching. Let's take a call. Thank you for calling. What's your comment? Hello.
Another great show.
Thank you. Who is
A
this?
horrible subject. They make the best shows for some reason.
I know. What's your comment, caller? Thank you for watching.
I'd like to ask the experts, who was the legislator that wrote the original registration law and the subsequent, I'm sure there were added amendments through the years make things worse, more burdensome?
I don't know. That was a move that was the national political move in the United States, and it was bouncing from government to government around the states.
Adam Walsh Act.
Yeah, well, that's
It had to
Adam
be a
Walsh.
state. I mean, a Texas.
Well,
I
it
can't-
started with that national Adam Walsh Act when they were worried about, you know, when they started doing the Amber Alerts and worried about children. And I think a sex offender did rape a child that he was next door to, so it got national news. And so from state to state, it started getting passed just with politicians.
The Texas statute was sort of channeled after the Kansas statute, which was one of the first ones. And after some of the Kansas statute was declared unconstitutional, one of the legislators said, but we channeled ours after Kansas. They told that to some authority somewhere, and they said, yeah, but that's been declared unconstitutional.
Yeah, but ours is still constitutional in Texas. So don't you think, caller, that it's just crazy that he would be scared to plead guilty to a crime when you don't register, and then a law comes and you have to register, and he has registered from 1996 until, and he got off probation in 2002, but you know you register for life. So he was registering until he was exonerated, which was this year.
May
Just
24th.
May
I don't
24th.
think it was crazy because didn't he say that he did plead guilty, that there was some sort of shenanigans going on there?
It's something going on there, but to get deferred adjudication, you have to plead guilty or no contest. But remember, I don't know if you've heard at the beginning, Mr. Trevino said he doesn't read very well. And when you plead, there's a lot of papers you sign, and nobody, even smart people, don't read it. Even if you're a lawyer, you're not going to read it because the pressure to sign it is so quick that usually your lawyer summarizes what you're signing and initialing, so you don't really get a good understanding. And remember, he didn't get to tell you much, but his lawyer got paid $10,000 up front and then wanted $5,000 more to work a little harder. But he's coming back and forth for 4 years and tells him, basically, I want to take your dad's property. Tell him about how you want to take your dad's property to go further. And it was some prime property in Austin on a lake, right?
Lakeway.
Yes.
Lakeway.
What it was is that he wanted an additional $5,000 to, I guess, somewhat he put it in words, to guarantee my freedom, you could say, and that he needed an extra $5,000. I started giving him money. I gave him $1,500 more. After that, I tried giving him another $1,000. He didn't want to take it. He started inquiring about my dad's property in Lakeway. And I told him no, that my dad would not sign the property over to him, that besides the case had to do with me and him, not that my father had nothing to do with it. And then when we were at the courthouse, he asked my father several times, and that was the wrong thing to do. My dad went off on him and told him no, and told him exactly what was going to happen, that after several months or years would go by, that he was going to pat me on the back and say, Mr. Trevino, I'm sorry, I did all I could do, and hang me out to dry anyway. And that's what happened anyway.
Isn't that crazy? So he had a bad lawyer that wanted his dad's property and basically tricked him into signing for something, saying you'll take deferred adjudication and it'll be dismissed. That is such a misnomer, because although the case is technically dismissed, it is always on your record that you can pull up. And actually, even though Mr. Trevino has been exonerated, one more interesting point I think is so interesting is that he doesn't have to register anymore. And registration requires basically every year on your birthday or within your birthday time, you go to the municipality. Like if you're in Houston, you go to HPD on Macau and you register. If you move within 7 or 8 days, you have to go register, which is how they get them, because in their birthday the next year they go and look at their house. If they're not there, that's when they get charged with failure to register. But one of the things that was bad about the registration is that DPS still has his picture on the website. Is that correct?
No.
I'm off the website.
You're off the website.
Yes.
But
What's-
DLS is still labeling him as indefinite flashing.
what is DLS?
The
Driver's
driver's license.
Driver's license. So the driver's license, Texas Department of Public Safety driver's license, still on his
Cannot-
driver's license says he's a sex offender.
Yes.
So if he wanted to go pick up his grandchildren from school,
Yes.
and they swiped his ID,
Yes.
it's going to show he's an
Indefinite.
He's an indefinite sex offender,
Yes.
and he's not.
They
Talk about that.
they
We're
say-
going to hang up, but if you want to call back, okay, sir?
Thank you.
As I understand it, they say that their computer program will not take the name off.
Cannot be removed.
I'll bet that if you get a lawyer and the circumstances arise so you can have that happen, over in Austin and you sue the DPS, I'll bet you they'll figure out a way.
Oh, I'm sure.
To get that off. But it's, you know, here again, the state ought to be paying for that.
Yes.
You shouldn't have to be paying for
Exactly.
that.
That's what we're saying.
And that's kind of the frustration of it.
That's awful. And the thing that's even more unfair to me is that, you know how if you have a record and you can pay a lawyer to get it either non-disclosed to the public or you can get it expunged. And you know how these independent services like People Search and these searches that get this information, you remember the law was enacted to where those you can sue those companies because every year they're supposed to go back and check to see if your record was sealed, non-disclosed, or expunged. And if they don't do it within a year, you have a right to sue them. Well, it should be the same thing with the driver's license, because there is a law that says you can sue if they don't take off something that's there.
Well,
so, and I bet they did not exclude the government. So I bet that you can actually sue under that statute.
Well, I've always maintained that the state will do anything you can't stop them from doing.
Right.
And I think that's what's...
So I think it'd be interesting for someone to look to see if you can sue on, is there a prohibition to suing DPS or DPS under that provision that says that you have to get rid of somebody's record within a year. Everybody who has a record of somebody is supposed to look every year. Because these independent companies are the ones you pay that $14.95 for People Search. And they've just gone to all of the municipalities and gotten information on people. But you need to get rid of the information if it's wrong because you're selling it and making money off of false information.
Exactly.
Right. And what they told us was when your husband needs to renew his license, just come back to see me. I hope I'm still working here when you come back. And we can just put you through like we put you through this time.
That is crazy. That's crazy. I mean, that definitely is crazy.
Yeah, because when I had to register, even where I lived in Lakeway for 9 years, they harassed me from time to time. They'd drive by my house. I mean, I'd see them like maybe before then, I would see them maybe like 2 or 3 times drive by. After I started registering and stuff, I'd see them go by at least half a dozen times just in the morning. In the evening, another half dozen or better times in the evening. And then there towards the end, in 2002, the detective, Jamie Nielsen, I believe was her name.
Jamie O'Neil.
And she said to Michael, she says, you don't have to come back no more. This is the end of it. I said, oh, thank you, you know, this, that, and I was excited. I went home, told my wife, excited. The following year on my birthday, I was going home. It was about 4:30. I noticed her little Jeep going around because when I going around my house. So I turned this other block to go around this other way. When I was turning, she came out, almost hit me head on. Her eyes got big like a deer seeing the headlights. And I didn't think nothing of it. I went home and I called her on her phone. It's Jamie, and no, she's already left for the day. I said, okay, because I seen her drive by and I was wondering about if I had to register or not. No, she's gone for the day. I said, well, I'll just take care of it Monday. Well, come 5 o'clock that Friday afternoon, I was in the shower. They come knocking on my door, take me to jail because I did not register on my birthday. And mind you, I've got 30 days after my birthday to register.
Right.
And here on my birthday at 5 o'clock in the afternoon, 5:05, they dragged me out of the shower, hauled me to jail for failure to register.
They're not doing this to just you. We all understand at this table.
That little community, yes.
But
law
police officers, law enforcement
is doing that in
does
Houston,
this
Huntsville.
all over the place,
Right.
all over the state. And there's 2 new cases that came out about the imposition of sex offender conditions of those on probation that came out in the last week. Are you familiar with those?
Little versus State and Donovan versus State. Both of those individuals were placed on sex offender conditions after they had, for non-sex offenses.
Yeah, they may have been charged with a sex offense, but they pled to injury to a child, so it's not a sex offense.
Right.
So go ahead.
But subsequent to that, they put them on sex offender conditions, and the courts, they were challenged afterwards, but the courts very specifically said if you don't challenge that condition when it's imposed, you may waive your right forever. Whether or not, they may engage in a legal fiction that you had an attorney, but if you don't object at the time they're imposed, you may forever lose that opportunity.
So if you get, your probation officer gives you this piece of paper and has you sign it saying, you're now on sex offender supervision, even though they told you you wouldn't have to be, and that's why you did the plea deal you did, and you will obey these. If you don't immediately file the court doesn't give you a hearing, although Coleman says they've got to give you a hearing. Most judges, or a lot of judges out in the hinterlands, don't understand about the Coleman and the due process that attaches to sex offenders,
Right.
who aren't sex offenders.
Right.
And the long and the short of it is now, if you don't immediately file a written objection with the court to these amended conditions, then you lose the right to claim them. And, you know, a bunch of these guys out here that are on probation don't have a lawyer anymore. How do they know they're supposed to do that?
Right. How would you know?
And it was either Little or Donovan. They not only pled to a lesser offense, so it was not a sex offense, the judge entered a finding. He expunged the record with regard to the sex offense, found that he was not guilty of that offense. It was a judge that got elected the following year who came in and reimposed sex offender conditions. In one case, when the individual was informed by his treatment provider that you're going to have to admit to the offense despite this, he objected to the treatment provider, but the court found, yes, but you didn't object in court. So you didn't object.
That is the craziest thing I've ever heard.
Well, we've made a career out of it the last 5 or 6 years doing these things.
If Michael had been unfortunate enough to have his probation revoked and had gone to prison,
oh my God,
he may never have gotten out. When you are convicted of a sex offense, in order to be paroled, I mean, he would have gotten out at the end of his sentence, but on parole. In order to be paroled, the parole board has to grant you parole, and in most of these cases, almost all of them, they require a sex offender program or sex offender treatment program or education program. And if you get if you draw the short straw and get the 9 or the 18-month sex offender treatment program, and you do not admit to the offense, if you're innocent and you don't admit, you failed out of the program, you go back to prison, you spend the rest of your time.
And the program is in prison. You don't get parole first. You got to finish the program before you can be released.
My husband was almost on his way to prison. Unfortunately, his probation officer judged him for his label. He did contaminate my husband's urine. My husband failed a drug screen in his office. I took him straight to LabCorp immediately after that appointment, and my husband's drug screen was negative.
Oh, that's awful. Can I take a call, please, and we'll get back on that, because those conditions are important. Thank you for calling and watching the show tonight. Give us your comments, please.
Yes, hello.
Hello.
My first comment is that to coerce, for an adult to coerce a child into a false accusation against anyone is bad enough, but to have them accuse their own parent falsely, that is an abuse, a pretty bad abuse in itself. And I think that parent should lose the child once that was proven. And I would love to see the law go out after the false accusers with the same fervor that they go after the accusers. I mean, that they go after the alleged offenders.
I know, and you understand then why our judicial system is so important, that, you know, people are innocent until proven guilty, no matter how bad the circumstances are, and why more people should go to trial. I mean, I would never have done what his lawyer did. I would have gone to trial and fought for his innocence. And if a jury doesn't see through it and convicts him, then deal with it up front. I mean, but I would never let someone plead guilty to a crime they didn't commit, that they're telling me they didn't commit. That's one of the travesties in our system, is that lawyers who are sworn to defend the Constitution will not always do it. And that's the thing that's sad, but they are in the minority. I would like to let you know that most lawyers will fight. Just think of how lucky he was to have a DA, because some DAs wouldn't have taken that on. Took it on and made sure that an independent person looked at it, not someone that was one of her assistant DAs, but actually a UT professor.
Would vehemently deny
exactly. Because when a DA did look at it in one of the other recantations, they said, oh, well, they believe the kid. But this DA in Austin, which was a different DA from before, because they elect different people in Austin, unlike here, she took it to an independent body, which was a UT law professor who was an expert in the Innocence Project, and they looked at it with fresh eyes, and she trusted their judgment. That would be a great thing to do here in Harris County, and maybe I'll propose that to the next DA. If people have a claim, we have 3 law schools here. We have the University of Houston, we have South Texas, and we have TSU, which the law school is called Thurgood Marshall School of Law, which I graduated from. And there are innocence projects at 2 of the schools, and I think the third school. All 3 have them now. So, I mean, this is the type of thing that our DA's office could use, because the DA's office is government run. I mean, it's county government paid, and then the schools are basically subsidized by the government, and those programs have grants. So these cases would be great for our DA's office to refer to look at those cases, so that their own DAs are not tainted and trying to protect their friends or their own integrity. Because one of the things our DAs do too often that saddens me is they go out on a limb actually believing what a child said without looking at the motivation for divorce. Certainly, divorce could be an issue to where the child felt safe enough to say it after the perpetrator was out of the house. But I think that it still needs to have a more strenuous investigation. Because a lot of times if you ask a kid that, I mean, there's nothing wrong with nicely asking a kid, you know, could it have been someone else?
I don't think it's hard to determine whether a kid is lying. I mean, that's just as a layman.
But you see, you don't understand how coddled this system is. I guess maybe 30 years ago they were too tough on victims. I don't know. But now, once a kid says it, they give them toys. They say we love you. So everything is positive to keep telling the same story. They practice it. So they never take them through a rigorous cross-examination, which they should do, but in a baby way. You know, a 5-year-old or a 7-year-old, you wouldn't talk to him mean or aggressively, but you would do it like you would do a 7-year-old. It would be in game and play, and you know, make a game out of another scenario just to test their credibility. But they don't do that, and that's what's bad.
All too often they start with the presumption.
Hello.
Go ahead. Let us know the other point.
Is that I am on the probation myself, and what y'all have not mentioned yet is the most egregious violation of civil rights is that we blatantly across the board cannot use the internet. And that's the thing that I would like to see some sort of civil rights case addressed.
Well, that's been addressed. And in several circuits, you have to show that the use of the internet is directly related to your crime. If they can't show that, then you get to use the internet with certain blockage on it.
What about here in Houston?
In Texas, we took a case to the Supreme Court that had that as one of the issues in it. And under the Texas law and under the circumstances of our case, we won at trial, we lost at the Fifth Circuit. We put some more evidence on during the second consideration. We lost again at the Fifth Circuit. We went to the U.S. Supreme Court, and that was one of the 3 issues. The U.S. Supreme Court called the case to conference 3 times. 3 times. So we know they were trying to get that 4th vote somewhere, and we were denied. So we didn't, right now the law in Texas is if they want to put it on there, they can.
Wow. But isn't it good to know that somebody fought it all the way to the United States Supreme Court and almost won? They need one more vote.
They denied cert is what they did.
Yeah. Right. They denied hearing it.
Harris County is one of the last that outright forbid it because they can't afford to monitor all of our systems.
Our judge in our trial case where we won that point said not having a computer today in this climate of adulthood is like not having a typewriter 30 years ago.
And the thing, like you're saying, is that there has to be some connection. It's different if it's internet child porn that you're convicted of. You could see where that could be dangerous. But if it's just me and him,
the thing is, they tell us we get profiled no matter what our specific crime. We get profiled as the person who does all of the things on the list.
Right.
And of course, they have tracking software now, so there's no need for that blanket prohibition, because they could require, as a condition of probation or parole, that you allow tracking software to be placed on your computer so that they can keep track of whether you're improperly going to certain websites.
That's a good point. Do you have another point, caller?
No, that's it. Just, you know, God bless your work. Everybody vote Vivian King in November.
Thank you, sweetheart. Good luck. I love you. Bye-bye.
You too. Bye-bye.
Okay.
Okay.
Okay, go
I
ahead.
was talking about my husband almost getting to be put behind bars by a probation officer that was labeling him for his, judging him for his label. And he contaminated his urine. After I got the documentation that my husband's urine was negative, I then requested a meeting with the director of probation. She granted us that meeting. We sat at a table. I informed her of what had happened. She then asked my husband how he was conducting his drug screenings. My husband told her that he goes in there, that the man would pull a cup out of his drawer, give
Out of the
him
box.
out of
Pull
the
it out of the
box
box.
that's already open, not in a sealed container, and hand it to him. He would urinate in this cup. He would hand it to the probation officer, and he would walk in front of the probation officer with the man having his urine behind him. So I then, the director asked him if he ever got a container that was sealed in a package. And my husband said, no, ma'am. And after that, my husband was given another probation officer, and his containers were sealed in packages.
Well, the good thing is that they have tried to do the right thing there, because we hear so much more horror stories here in Harris County. So it sounds like they tried. And let me tell you, in Harris County, another thing that's interesting about your case, although you should not have been on probation and your lawyer was wrong for let you plead and get probation, the fact that you never admitted it, because here in Harris County, when you're on sex offender probation and you never admit it, that's a violation. They revoke you and send you to prison. Talk about that, Bill.
Well, for example, if you're in prison and you're in the sex offender treatment program before you're paroled out, and you refuse to talk about your guilt because you're not guilty, maybe you're one of those people, and I think there are a lot of them out there, they will kick you out of the program, or they'll put you in close custody as punishment, unless you have a lawyer who will represent in writing to the prison and to the therapist that this person is your client and that either litigation is underway to challenge the conviction or that you are on the verge of filing litigation to challenge the conviction based on actual innocence. In those instances, the prison has had to back off, and they will not pursue punishment for someone who refuses to discuss something they didn't do in the first place.
Well, we have 5 minutes, so let's start wrapping it up. So give us a 60-second comment, and then Dave will go to you, and we'll just go all around the table.
Well, I see 2 or 3 things. First, I think their story is just horribly fascinating. And I'm glad that they're getting the opportunity to on your show, to have their story told. But we have several things here that we keep seeing in our practice, which is prison and parole and post-conviction stuff. We see it all the time, where it's not necessarily that, I'm going to give lawyers the benefit of the doubt, that they intended to mislead or to be evasive about information regarding what happens, what are the collateral circumstances, what are the collateral things that attach to getting a felony conviction. There's not a law school in the state that teaches that. There ought to be a little 1-semester, 2-hour course where you survey time credit, disciplinary action, health problems in prison, where those future lawyers at least know what books you go to or where the topics are, and discover that there's loads of law in this area. And I think that's part of what happened to you. And I think that's going to continue to happen with these new cases we have, where they just send you a letter, and if you don't immediately object in writing in court, then suddenly you're on sex offender supervision.
Thank you. So, Dave, what are your closing comments?
I think that one point that Michael mentioned that you had touched upon is really one of the big problems here. And sex offenses have taken on such an air of credibility in the current day that what we find, instead of a CPS organization or investigative agency taking a witness in with the purpose of finding out if they're credible, they take them in with the purpose of ensuring that their case will be made. And until we change that mentality, we're going to continue to see these kind of wrongful convictions, these kind of false allegations given credibility. And don't mistake me, there are most cases that their allegations are made, they are true, and victims have to be treated with respect and dignity because of that. But there has to be more forethought by CPS and investigators into how they approach these to make sure that these kind of cases are ferreted out well before 20 or 30 years of punishment has passed.
What do you want to say?
I'm going to close with the back end of what Dave had to say, and what I would like to see is I would like to see our justice system make a change in how they address victim services. You can walk into any government agency that has victim services that are offered to victims, and it labels moms, mothers. Not anywhere in their information do you see language about a father, about the dads doing right. I think that in this day and age that mothers have too many rights. Women are given the right to go and place an accusation on a man, and that man will pay for it for the rest of their lives. These women sit back and they live their lives, and they laugh and sit and humiliate, demean, and degrade your life. I believe that there must be investigation before punishment. This day and age, it's not innocence. Prove your innocence. Prove you're guilty before you're however.
Right.
It is when you're labeled, you're guilty, and they have to go out and make a change in the way they do these investigations.
I agree with you. Okay, Michael, what do you have a closing comment you want to make?
I just want to say thank you to everybody that's watching the show, and thank you to the lawyers, and thank you for letting us tell our story, and just hope to God that this does not happen to anybody else, because it's hard. It's not easy.
I know, sweetheart.
It takes a lot of money that we didn't have, that we could not afford. But thank God that we were able to do what we did and get off, for me to get off of the registration, and I hope not another family has to go what I went through for a vindictive wife.
God bless you. God bless you, sweetheart. God bless you. What I want to close in saying is that this is a heartbreaking experience. So please, mothers out there and daughters, don't falsely accuse people of things they didn't do. And just think that Michael never had a relationship with his children. He had 2 small children when he married Sandra in '87, and he never had a relationship with them. But by the grace of God, his daughter came to him and insisted upon telling it. The part of the story we never got to tell is that she had 2 children by her second stepfather. So it was a pattern of stepfathers raping her. The first stepfather, when they falsely accused her dad, and the second stepfather, who she has 2 children for, because the mother married another man that was as young as she was. So just think of how twisted this whole saga has become, and how much courage it took for the daughter to come and tell the truth. But how many daughters don't do that? So again, my point is to educate you through story. I hope I brought you another interesting story to educate you, to be involved in your community, come to jury duty, really listen to people on the jury to make sure that the right thing happens and not the wrong thing. Make sure that you get out and vote, and that you support your leaders. Make leaders that don't have to say what you want them to say, but respect what leaders say even when the leaders don't say what you want them to say, so that we can have a fair and just system, so that it won't be so warped and one-sided, and another person's life doesn't have to be ruined for 20 years based on false accusations. So thank you again for watching Truth and Justice with Vivian King, and we'll bring you another exciting show next Wednesday. Thank you. Thank you for tuning in again. Tonight we have something really good, a hot topic in the news this week. We've been charged with crime. This is a show where I try to